judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we will hear initially White versus Warden, and Ms. Medill, you.
Thank you, Your Honor. Good morning. May it please the court, Claire Medill on behalf of petitioner appellant William White. This case presents two issues of first impression in the circuit. Did the BOP wrongfully deny Mr. White first step time credit acts for the time he spent in transit or transfer designation status? And do federal inmates have a liberty interest protected by the Due Process Clause in earning First Step Act credits? The court should answer both questions in the affirmative. As an initial matter, the government has forfeited and waived a response to both questions. At the very least, this court should reverse and remand for the district court to apply the correct legal standard. It did not apply the proper legal standard for either question. For the statutory question, it applied the now defunct Chevron standard. And as to the due process question, it did not apply the two-prong test that applies to determining regulatorily created liberty interests. In any event, on the merits, the regulation invoked by the BOP to deny credits that Mr. White was in designation status outside the institution did not apply to Mr. White. He was never outside of a BOP institution. In any event, the regulation violates the text of the FSA. The FSA mandates that once a prisoner's sentence commences, he must have the ability to earn First Step Time Credit Acts.
This whole program is called Earned Time Credits. And how does one earn time credits? Simply by being incarcerated. What have you done to earn the actual credits?
Well, Your Honor, first of all, I want to push back on that. This court can consider that issue because the government did not raise it below. This is a brand new argument. This is a civil case. You normally don't.
Well, I know, but you can affirm on any ground that's evident from the record, and I still have a question of what he did to earn it.
Well, can I?
Which is that earn implies some degree of effort.
Yes, Your Honor, I'll answer the question, but two other points. I don't think this court can affirm. Under the Chenery Doctrine, you cannot affirm an agency action based on a reason not invoked by the agency.
I'm interested in hearing the answer to the question.
Yes, I know, but I just wanted, and I wanted to say that we don't have any evidence that he did not successfully participate or what was offered to him below. So we cannot, this is a motion for summary judgment.
We're looking at Judge Chazanow's ruling. We're not reviewing this purely as an agency matter. We're looking at the district court's ruling.
Yeah, and the district court didn't rule on this ground either. But I will answer the question. This is a weird case because the government is taking a position that is contrary to the policy and practice of their own client. Their own client's view is that if you are willing and able to participate in programming, you are successfully participating. He is earning credits because he is successfully participating in the overarching EBBR program.
I'm looking at the statute here, and it talks about time credits. And it says, completes evidence-based recidivism reduction. What evidence evidence-based indicates that some evidence is created and that the recidivism reduction was warranted. And we don't have an evidence-based determination here, do we?
Well, Your Honor, I believe that evidence-based recidivism, the term evidence-based in that context is referring to the direction to the BOP to pick programming that evidence shows does reduce recidivism. I don't think, it's not an additional requirement on top of it. We have EBBRs and PAs. And on this record, we have no evidence that Mr. White didn't successfully participate in PAs.
Let me ask you that more particularly. I wanted to follow up Judge Wilkinson's question initially when you were going off on the other direction. And he was at the Federal Transfer Center,
yes.
Right? And he did not, there's nothing in the record to indicate he participated in any program there, right?
Well, that's because the government didn't raise this below, so
I
he
don't
didn't
care
know he had
whether
to present
I'm
evidence.
talking about, is there any evidence that he was participating in a transfer center? I
He
mean,
pled
what-
in his petition that he was willing and able to participate, which was the successful participation requirement that BOP required.
It
So
would help if you would just answer my question. This was a transfer center, right?
there's no evidence whether, it was a transfer center.
And he was being held there to be transferred.
Right.
And so there's no evidence and there's no logic for evidence that in a transfer center, you're going to be offering programs.
I disagree with that, Your Honor. In a case called Corrales, which we cited, the BOP represented that productive activities are available at all institutions. In Jackson v. Doer, a CD California case, that prisoner, quote, continued to participate in FSA programming even though he was in transit status.
It's your burden to produce some sort of evidence that you've successfully participated. That's not,
He did,
that's your burden.
well, Your Honor, the government has the burden of proving they're entitled to summary judgment, right? And they did not raise this argument. So Mr. White pled what he needed to plead, that he was successfully
Whether they
participating
raised it or
as
not,
BOP.
it would be decidedly to your advantage to produce at least the slightest evidence of effort on your part and of participation on your part, because participation implies that you do something.
I don't know how Mr. White, who was a pro se petitioner, was supposed to know that he needed to plead this when it wasn't BOP policy and was not raised by the government.
Now, it says here that a prisoner shall earn 10 days for every 30 days of successful participation. And we have no record of successful participation. And your position basically is that somebody should get earned credits simply by virtue of being incarcerated. And that has no relationship to the whole purpose of the program, which is to ensure that somebody, upon release from prison, is able to reintegrate themselves into society in a lawful manner.
Your Honor, I disagree. My position is not that if you're sitting in prison, you earn credits. You have to be opted in, and if you refuse to do any programs that the BOP recommends or requires, you will be opted out. So if there was a situation where they offered programming in the transfer center, which we don't know, and as I don't think I mentioned this, productive activities is very generously defined to include crafts, church services, so he could have easily done productive activities in federal transfer center. But he's not just sitting in prison.
Well,
If the BOP tells him to do something, he has to do it.
What's the evidence of that?
Of the productive, yeah.
In the transfer center, I'm concerned more particularly about the particular circumstances of Mr. White. And he was in a transfer center. He wasn't being assigned to a particular institution at that point. He was waiting to be transferred to the institution to which he was assigned. So my question is, in a transfer center, in this transfer center, while he was there, number one, was there any one of these programs being offered? It would surprise me. But number two, is there any evidence he participated in any sense in any program or activity, positive activity?
Your Honor, I would point to Corrales, where the BOP itself represented that productive activities are available in all institutions. They did not say all institutions except for federal transfer centers. And my understanding, just working with clients, is people in transfer centers do work. They have jobs. That's a productive activity. There's churches. That's productive activity. And again, I don't know what to say because the government, Mr. White pled what was required under the regulation. And now we're saying because the government has, sandbagged us on appeal, he loses. That's kind of the position I'm hearing.
In response to the government's motion, what did you put in response?
What motion?
To dismiss or summary judgment?
So in the government's arguments were.
No, I didn't
When
ask
did you
that.
get in this case?
I was appointed on appeal.
You're in on it, he was pro se.
Yeah, he was pro se.
But he was in 3 federal facilities.
Right.
Terre Haute, then they moved him to Oklahoma City. That's what they referred to as the transfer center.
Yes.
and he was in Oklahoma City for several days.
Correct.
And then he went to Cumberland,
Right.
FCI Cumberland, Cumberland, Maryland. That was the goal, to get him to
Yes.
Cumberland. They had to take him from Indiana to Oklahoma City to Cumberland for whatever reason, because that was the transfer center. I guess they do all of them that way. And that's right. And he started this thing on his own. He didn't have a lawyer until you got into it
Correct.
on appeal.
Right.
And you argue 4 bases for you claimed he could prevail on, right?
For the statutory ground, yes.
The statutory ground.
Right.
Yeah, I'm focused on the statutory ground.
Yes.
You agree that if you can prevail on the statutory ground, we don't have to deal with the due process ground.
Right. And I also agree with the other way,
There's
too.
a thing called Ashwander, right?
Yes.
Which of those 4 grounds is the best ground you got?
Oh, I think that the regulation does not actually apply to Mr. White.
Which is the 4th ground?
Yes.
Well, that's the one I thought was the best.
Thank you, Your Honor.
That
I
the
agree.
regulation doesn't apply to him.
I was going to get to it before we jumped into successful
All right.
participation. The BOP says he doesn't get
The
credits.
government really doesn't really even argue that it applies.
Yes, they've conceded I think they've conceded that argument is meritorious. So this court could reverse on the ground that the regulation didn't apply to him, send it back. And when they do,
And then we don't have to deal with any due process grounds or anything. And we're talking about, what, 1 day?
yeah, I think it's 1 day of credits and 4 days of participation.
1 day of credit and 4 days of participation
Correct.
is what the case is about.
Yes. And that's because.
And it's the 4th ground. Why didn't you make that your 1st ground?
Well, I thought that the government would make certain arguments that they have not made. And it seems so simple that I thought perhaps I was missing something, but then the government didn't respond to it. So I agree. This court if this court reaches the sexual participation argument, you are going to be affirming on a ground not briefed below, not considered by the BOP. And I actually think the BOP will be unhappy because this is not the program they have now. You will be asking the BOP to completely change their administration system. They're going to have to start tracking actual successful participation down to the hour. They've complained that they don't want to do that. And so I think you could easily just reverse on the regulation didn't apply, send it back. If the
But the core point remains that, and the whole purpose of the program means, and the statute directly stipulates that there should be some successful participation. That's would be, whether you are pro se or not, it would seem to be obvious that you would put forward evidence of something that would amount to successful participation. And there was nothing.
But if you are a pro se prisoner who receives this message from the inmate, from the BOP, which is on J898, the earning of FTCs is based on earning status and not participation and or completion of individual programs. If you are told that, which Mr. White was, why would you think you needed to plead more than saying, I satisfied the Bureau of Prisons' definition of successful participation? And we have here, the government's arguing you should give Chevron deference to their transit exclusion. Well, if that's true, give Chevron deference to their definition of successful participation. Everyone agrees that it's not defined in the statute.
Why don't we just look at the statute, what Congress enacted?
Well, the other thing is the court is ignoring that we have to consider the statute as a whole, and over and over and over again, Congress has made it clear it wants inmates to be able to successfully participate at all times.
But it talks about participation and earning. It uses those terms with the idea that these programs will benefit. And if somebody just sits there and does nothing, has earned nothing, has participated in nothing, it seems to me that frustrates exactly what Congress.
Well, Congress also wanted to reduce the prison population. We're just ignoring that purpose altogether. But what do we do with the language that's saying the BOP shall provide?
Reduce it without participation, without returning credits. They could have done that. But under this particular program that you're invoking for the few days we're talking about, Congress specified pretty particularly, I thought. I mean, you can argue about what successful means, but we're not even at that threshold successful. We're talking.
Well, 'cause the government
We're
has
talking
not
about
done it.
the fact is non-participation. There was zero evidence of participation while at the transfer center.
There's also zero evidence of non-participation, but if the implication of these arguments is that the BOP could just say, you know what, we're no longer offering programming at Cumberland at all. We're not going to do it, and therefore no one can earn first step
Well,
credit.
this particular program, when you look at the statute here, it says, a prisoner determined by the Bureau of Prisons. And it's exactly the kind of program where Congress has committed the whole question of earned time credits largely to Bureau of Prisons administration. And we're not in a situation here to overturn the Bureau, what the Bureau of Prisons is asking and what the district court found in terms of successful participation. It's up to the Bureau of Prisons to define successful participation. And it's your burden to prove that something was done, not that one just sat. Because the whole purpose of this is to prepare an individual for reintegration into society, and you do not prepare anybody for anything if there's no participation and nothing earned. That's the core of it all.
Your
I mean, we can try to work around, but that's the core of it.
Do you mind if I answer? I know my time's up. I can also sit down.
Well, you have time assigned for rebuttal, but you can go ahead and answer,
Okay.
but I'll take your time off.
Okay, Your Honor, I strongly disagree that the FSA is delegating discretion to the BOP. If you read it, it is so detailed, it has so many mandatory languages, it's showing that they are taking discretion away from the BOP, unlike the past. Putting that aside, you cannot defer to the BOP if it is contrary to the statute. And we have made an argument that this transit exclusion is contrary.
I could not agree with you more, and that is why the statute has words such as earned and successful participation, of which there is none.
We have no briefing, Your Honor, on what successful or participation means. None. The government didn't do it, and we didn't do it.
Do we have any participation? Why do we need to talk about successful if there's no evidence of participation at all?
I can only repeat below, which is the pro se prisoner pled what the BOP requires, and now on appeal he's being sandbagged. If the government had raised this below, he could have responded and said, here's my evidence of participation. They have the burden of proving summary judgment is satisfied.
Can I just ask? He is pro se, but he is invoking some good time credits or some time credits that are provided by statute that are earned based on participation.
Yes.
Now, the fact that some prison official says you don't have to participate in anything doesn't relieve him of the duty to satisfy the statute.
Not some prison official, the BOP as a whole.
Even the BOP, now you're looking at some form of estoppel or something, but you're talking about whether he gets good time credits under the statute.
So what is the point of...
Just a minute.
Yeah, sorry.
And you talk about successful completion and this type of thing. Well, I'm talking about evidence of any participation. In other words, there has to be some active conduct on his part, and there's no evidence of that. Now, you say he's pro se. Well, that's true, but do we excuse the fact that he doesn't have to satisfy the statute because he's pro se?
I do when the government doesn't raise it, but he did plead active participation. He said, I am choosing to participate in the BOP program as they have said it. And we haven't talked about this at all. Congress said over and over and over again, the BOP shall provide programming at all times to all prisoners. So the point of this argument is, it's not Mr. White's fault that if there was no programming.
I've listened carefully to your argument, and the one thing that occurs to me that I have not heard in your argument is normally some if someone wants a remand, you would say, well, on remand, we can do this, this, and that, we can do A, B, and C, and it would not be that hard for you to say, well, if this were remanded, we could present A, B, and C in terms of successful participation, and we can tell you about this. Give us a chance to develop the evidence of successful participation, and you could give us some reason to believe that there was some effort or some participation of any, as Judge Niemeyer points out, of any kind. But through the entirety of your argument, there has been no suggestion that on remand, evidence of successful participation would be brought forward.
Well, Your Honor, I am asking for a remand to develop the record. I'm not trying to go outside the record and say, I mean, we will present evidence, as I pointed out.
But you haven't given us one sliver of how the record would be developed. You say, we just want to develop the record.
What about the part in the joint appendix that defines productive activities as crafts?
I've given you.
Yes, you have given
a
me.
good bit of, and you still reserve some time for rebuttal, so we'll look forward to hearing from you then.
Thanks, Your Honor.
Ms. Thomas, we're happy to hear from you.
Good morning, Your Honors, and may it please the Court. My name is Beatrice Thomas, and I represent Respondent Appellee, the Warden of FCI Cumberland, in this matter. The Warden asks that you affirm the District Court's holding in its entirety. In writing the First Step Act, Congress created an incentive-based program where, if an inmate successfully participates in evidence-based recidivism reduction programming or productive activities, BOP shall award them credit. But Appellant White seeks to rewrite that framework, wanting you to take into consideration only the word shall, without considering the condition precedent, which is successful participation.
How about any participation? Is there evidence of any participation? We're talking about the time spent at the transfer center, right?
Yes, Your Honor.
And that's what has denied him these 4 days or whatever we're talking about here.
That is correct, Your Honor.
And is there any evidence that he participated in anything?
No, Your Honor, and that's the one thing I want to point out. There is no evidence whatsoever.
Is there any evidence of anything?
There is no evidence.
There was no evidence taken. There was no discovery. There was no evidence taken. It was an ex parte proceeding until it got on appeal, wasn't it?
Well, Your Honor, what's most important is, first, his petition only asked or only requested, he said that he was entitled to due process when he did not receive credit for 4 program days because he was in the transfer status. He was in a transfer center. At no point whatsoever, either in his petition or even presented to the lower court, did he say, I was successfully participating and I was not given credit for that successful participation. The reason why BOP, or the reason why the argument was never made below.
He was doing whatever the BOP had him do. He was in their custody. They had him at Terre Haute, and they moved him to Oklahoma City. He stayed in Oklahoma City until he was moved to Cumberland.
That is correct, Your Honor.
You all were in charge of him.
Yes, Your Honor. We are in charge of the inmate, and of course, we have to administer
You
the
were in
sentence.
charge of him every minute he was in Oklahoma City.
That is correct, we were. And at no point while he was in Oklahoma City did he request to participate in programming. There is no evidence in the record, nor does he present any
He did
evidence.
everything in Oklahoma City he was supposed to do. There's nothing to indicate otherwise.
Well, while he was in Oklahoma City, what happens with respect to the evidence-based recidivism reduction programming pursuant to the statute is that they are assigned programming. Then they are to sign up for that program and they can complete that programming. White in no way at any point in time in the lower court or even in his petition in any response ever indicate that he asked for programming, that he had been assigned programming, or that he attempted to participate in that programming and BOP did not permit him to participate in that programming. What White alleges in his petition is that he was in transfer status for 4 days, which is well within BOP's discretion, and while he was in transfer status during those 4 days, he was entitled to earn time credit. BOP did not give him those credits because he was not successfully participating in any evidence-based recidivism reduction programming at that time.
But if there'd been if he'd even requested it and said, I would like to participate, or I'm willing to participate, but we have nothing. We have no evidence of participation. We have no evidence of a request for participation. There's just nothing, normally, this was at the administrative stage. This went through the district court. Nothing was ever brought before the district court that indicated participation. Nothing has been said before this court that indicated on remand what evidence of participation would be brought forward. At every stop along the way, there was no evidence of participation or request for participation when it would have been in the obvious interest of the appellant here to do so.
How do you get around that regulation?
Well, Your Honor, what we would say is that the regulation is meant to establish what successful participation is. Here,
And it states that an inmate will generally not be considered to be successfully participating in situations including but not limited to designation status outside the institution. For example, extended medical placement in a hospital, outside institution, an escorted trip, a furlough, etc. How do you get around that?
well, Your Honor, I would like to say, or what the warden's position would be, is that that list is not exhaustive. Obviously, that list does not.
Well, they got et cetera there, whatever that means. In the regulation, it says et cetera.
Well, Your Honor, and that's exactly what the regulation says, and that's because that regulation doesn't list out every aspect of BOP's administrative management of an inmate's sentence, or while the inmate's in the care, custody, and control of BOP. There may be other instances, as you noted, et cetera, where BOP is administering one sentence, doing something that is well within their discretion, like transferring a prisoner, and that person would not be in a situation where they would be earning. They would not be assessed for earning. They would not be participating. They would not be assigned to participate in any evidence-based programming. And when we look at the purpose of the First Step Act, it is to reduce recidivism. Appellant's counsel was correct. It was to reduce recidivism. It is to make sure that prisoners, or it is to get prisoners out, to reduce the prison population. But one point she's missing is that it's to ensure that they don't come back. That's the whole point of ensuring that they participate in evidence-based recidivism programming. Those incentives were given. If you participate, then you will gain credit. And a good example for this is a train. You get on the train goes forward if you are participating. If you're not participating, you're not moving forward. And this court asked the parties to...
The question is, did he even request it? Did he even want to? And you don't, I mean, if you're giving us something to work with, that would be one thing. But if somebody not only didn't participate, but didn't ask to participate, there's no evidence of a desire to participate, to award earned time credits under those circumstances would turn this entire program and the First Step Action in what it sought to achieve, an absence of recidivism, and we'd be turning it on its head.
Exactly, Judge Wilkinson. Exactly. And that's why the warden's position is that inmates do not retain a liberty interest in earning earned time credits. It requires the satisfaction of too many prerequisites, specifically their actual participation. And again, there are a number of other...
That's in the statute.
That's correct, Your
And
Honor.
the statute trumps the reg, whatever it is, but that's statutory. We can't ignore it.
That is correct, Your Honor. That's exactly the warden's position here, and that's exactly what the district court held.
Now, you'd agree that this is an escorted trip?
Yes, Your Honor, the BOP took him
No
from...
question, this was an escorted trip from Terre Haute to Cumberland.
I'm sorry,
By the way, it
can
was
you...
escorted trip. And that, in the regulation talks about escorted trips.
Yes, Your Honor, exactly. And so again, we have the statute. And again, there is authority that the Congress, in not defining successful participation, gave BOP in telling them to create these programs to ensure that inmates have access to them, gave them the discretion to define what successful participation is. And obviously, BOP has defined that there are instances where
What's Loper Bright got to do with this?
Well, Your Honor, first of all, under stare decisis, the court doesn't need to readdress Loper. This case was decided 2 years before Loper Bright even came out. The court properly considered and gave deference to the agency's decision. But even if this court wants to consider the district court's decision in light of Loper Bright, the courts can still defer to the agency's interpretation to the extent that the statute allows the agency to fill in details of the statutory scheme. That's exactly what we have here. Congress intentionally does not define what successful participation is. BOP does. BOP explains what successful participation is, when you're successfully participating and when you're not. And again, as Judge Niemeyer and Judge Wilkinson points out, we don't have any evidence whatsoever at all that White was successfully participating. He doesn't say that he was successfully participating. He doesn't say that he attempted to successfully participate. He simply says, I was in transfer status. I am due these earned time credits, having not done anything with respect to earning them.
But we haven't been given anything, any hint, any tiny little hint as to what would be developed in terms of participation on remand. And that's not that hard to provide.
I would agree with you, Your Honor, and I think that the reason that we haven't been given any tiny hint is because there is no hint. There is nothing for them to provide. Appellant White can't provide anything to this court, even on remand, because his petition doesn't say anything, and that's because he wasn't participating. He has no evidence to offer. He had no evidence to offer to the district court, and he has no evidence to offer to this court that he was successfully participating, had asked to successfully participate, or had done anything to meet what Congress laid out as required in order to earn these time credits.
You have to give an appellate court something to work with, and we have been given nothing.
I agree. I agree, Your Honor. And so, again, if the Honor has no more questions, Your Honor, we would just ask that this court specifically affirm the district court's holding that there is no due process interest in earned time credits, and uphold the district court's application of the program statement that he was not entitled to credits at this time while he was in transfer status. Thank you.
We thank you, and we will have, Ms. Medill, you have some rebuttal time.
Thank you. First things first, I want to make clear we are asking for remand because this wasn't raised below. I don't want to represent things outside of the record to this court. However, in the JA, it does define productive activities very broadly to include crafts, recreation, visitors. And so on remand, if Mr. White participated in any of those, we would satisfy the PAs.
Well, his petition seems to assume he did nothing because the Bureau of Prisons assigned him to a special housing unit while at the transfer unit because he was a domestic terrorist. And he said it was a single bed in the housing unit apart from the facility, which suggests, he sort of implies that he was denied the opportunity to request anything in that context. But the fact of the matter is that still doesn't get him the credits. He didn't request them, and he didn't.
We don't know that.
He didn't say. He implied that he was assigned to that, and as a consequence of that, he was separate. And I think when he got to Cumberland, they did restore some days, didn't they?
Because they changed their policy about the shoe.
I didn't ask because. I said.
Oh, yes, they did. They restored some, yes. I would also say, if this successful participation argument that he should have pled this was so obvious, you would think Judge Chazanal would have addressed it.
Even suggested. I mean, it's not even common sense. This is a transfer unit. During the transfer, he was isolated from the prison population because he was a domestic terrorist. He was put in a special housing unit for 4 days and then transferred to Cumberland.
Then why didn't
This does not sound like he participated in anything, even though he didn't allege it.
I would have expected that if it was so obvious, would have been the basis of Judge Chazanal's decision, and it was not. But I also wanted to say, I just wanted to clarify one thing. BOP's definition of successful participation as being willing and able to was promulgated in a regulation followed by notice and comment, the same one that the government wants you to defer to. They had a much more stingy interpretation of successful participation. There was over 150 objections in response, including from people who drafted the First Step Act and said this interpretation of successful participation is too narrow. We want prisoners to be able to do it all the time. And then that's when they accepted the willing and able. So, and finally, I just wanted to say, we have to pay attention to statutory language, including the language over and over that says the BOP has a statutory duty to provide programming at all times. They shall do it. It's in there at least 4 times. So if this court affirms on the successful participation, they are saying, because through no fault of the prisoner's its own, because the BOP is violating its own statutory duty, Mr. White does not earn First Step credits, which is contrary to the intent of Congress in passing this. We ask this court to reverse and remand for consideration of the correct legal standards, not the legal standards that were applied below. Thank you.
All right, we thank you, and Ms. Medill, I see that you're court assigned. I want to express the court's appreciation for the argument you've given. If you'd like to come up, give me a fist bump.
Thank you for appointing us.
Okay. Ms. Thomas, will you come up and...
We're going to go down.
Thank you. Be seated. We'll proceed into our next case. Please.
Good morning. May it please the court, my name is Jeffrey Fogel, and I represent the plaintiff's appellants in this case. It's of course interesting to me to come here today and see that you had another case about earned sentencing credits. But I don't think the issue that you had in that case is applicable here, because nobody has contested the fact that had Mr. Miyares not issued his opinion, had Mr. Clark not revoked what the legislature had done, that the plaintiffs would have been entitled to be released as of the date designated by the legislature, which was July of 2022. As you know, my clients weren't released until 2023 because of the habeas decision of the Virginia Supreme Court in the Priest case.
You're suing the Attorney General under 1983 and claiming a civil rights violation. That's correct?
Yes, sir. I'm sorry, Judge, you were about to ask something?
For an opinion letter
Yes.
on a legal issue.
That's as to Mr. Miyares. But as to Mr. Clark, the only defense raised for Mr. Clark in the district court really was he relied on the advice of counsel. But as we know from the record, there were 2 different advices on this issue from counsel.
And the issue here is whether the Attorney General is entitled to qualified immunity.
Well, I'm sorry, I didn't quite hear that. I'm
Qualified
getting to an
immunity.
age where I'm...
Qualified immunity.
Well, that's the other issue, yes. From the plaintiff's, appellant's perspective, the key issues in this case are whether or not we have at least pled a plausible case of deliberate indifference.
Couldn't you have pursued a remedy in state court? Because we're talking about a state official who you allege has violated state law. Is there a remedy for you, and would there be a remedy for you under state law?
I don't know the answer to that, Judge. We looked at the law and basically decided that the violation of a vested liberty interest raised constitutional
Well,
implications
see,
both
this-
under the 8th and 14th Amendments.
This is my problem, Mr. Fogel, and it's a problem of federalism, really. And I think it would be a very aggressive ruling to hold that a federal court could hold a state official liable for damages because of a dispute over the interpretation of state law. I mean, people disagree over the interpretation of laws all the time. We have disagreements among our court. We have disagreements among the attorney general, from one attorney general to the next, and everything. But the fact that one has a disagreement over a matter of law doesn't mean that you get to sue that individual for damages over a question of legal interpretation, which and particularly a federal court suing holding a state official liable for damages over a disputed question of state law, that really seems to me to present a problem of reaching into the state's administration of its laws. And I can't imagine the number of suits that would unleash here.
Well, Your Honor, it's not merely a matter of a disagreement of law. And I'd like to review how the district court looked at that opinion and answer why it is we believe the district court was wrong and why it is that that opinion went beyond mere
We're
negligence.
fighting over two legal opinions by two attorneys general that opposed one another. Lawyers disagree all the time, and that's not a sort, and one side usually loses. And to hold
I
the
don't-
lawyer liable personally, the 1983 suit's personal.
But we know that's a fiction,
But
Judge,
to
because
hold a lawyer liable personally for a legal opinion that was later determined to be incorrect.
well, again, it's
That's a
not our
big
position that merely because it was incorrect, that gives rise to a violation of the 8th or 14th Amendment. We say he was deliberately indifferent.
No, but there you run up against the finding of the district court that said that the Attorney General looked at the text of the statute, he consulted the canons of construction, he looked at the larger purposes of the statute, and he came to one conclusion. But the district court, far from finding that he was deliberately indifferent, found that he'd gone about the task of legal interpretation in a perfectly conventional kind of way. At the end of the road, you have two people disagreeing, but people disagree within the legal universe every day of the week. That's why we have an adversary proceeding, because disagreements arise. But the losing side of a legal dispute should not likely be held up in damages. And that's particularly true where you're talking about a state's interest in the administration of state laws, and having a federal court hold a state attorney general liable for damages over an interpretation that others may disagree with. That seems to me very adventuresome.
I hear what you're saying, Your Honor, but may I react?
Sure.
And discuss what the district court found? As you said, the first thing the district court found was that Mr. Miyares, quote, carefully considered the text of the statute itself. Well, from what we stand for, had he done so, we would not be here today, because the text of the statute was clear, unambiguous, and there was nothing to decide, nothing to interpret. The trial court also found that the defendant properly applied the canon of absurdity. But the Supreme Court went ahead not only and rejected that, but reminded the defendant, Mr. Miyares, that we have consistently explained that the doctrine only applies when a statute's internally inconsistent or otherwise incapable of operation, which is not the case here. Finally, the district court found that Mr. Miyares appropriately considered the intent of the legislature, a common practice in statutory interpretation.
Well, that's fine, and then you don't, everything doesn't trace back to the Constitution, and you can go at this through state law, but instead you've brought an Eighth Amendment claim, which normally applies to prison conditions, and the habeas is what you normally, the vehicle you normally use for the fact of detention, but you brought an Eighth Amendment claim which says, is it some sort of infliction of cruel and unusual punishment? This is a prison conditions. Eighth Amendment is reserved for prison conditions. And so you say, well, let's go to due process, but that has to be something that shocked the conscience, and substantive due process is probably the doctrine least favored by the Supreme Court these days. So when I'm thinking about why is this being brought up under the Eighth Amendment? Why is this being brought up under substantive due process? Why is this being brought up in federal law by virtue of 1983 rather than through the normal channels of state law and state administration, which is the position Mr. Miyares holds?
It was done, Your Honor, because the case law said that's the way to go. The case law says that over-detention cases, most of the case law said that over-detention cases should be analyzed under the 14th Amendment. But many courts have decided, circuit courts have decided this under the 8th Amendment. So as a lawyer, I'm sitting there reading the cases coming from all over the country. They say 8th Amendment, they say 14th Amendment. What's a lawyer to do? But rely on the substantive, overwhelming authority that we presented in our brief, that this can be considered under the 8th or the 14th Amendment. Now, frankly, from my client's perspective, we don't care whether it's the 8th or the 14th Amendment. You know, our claim is, and I refer this court back to the Wilson case, where the court said where a state official wrongfully detained somebody past their sentence, a viable claim is stated. Now, this court didn't say under what constitutional provision, but it did say that's a viable claim. And I hear what Your Honor is saying, but
Sir,
I just want to finish. I'm sorry.
how do you handle our decision in Campbell versus Florian? It seems to me we had a similar situation there,
And you were on the panel.
I was on the panel, but the question really goes mostly in this type of case to a state of mind, some kind of mens rea. And here we have an attorney general being asked for his advice, and he writes an opinion letter. And it's not directed at any particular defendant. It's written at provision that he is construing. There's no Supreme Court of Virginia case. He's construing it the way he thinks is best construed. And we said it's inappropriate to bring a suit under that. I mean, you're seeking some kind of deliberateness, maliciousness, some kind of indifference, deliberate indifference. I'm not sure which standard you'd prefer, the 8th Amendment or the 14th, but both of them have some kind of mens rea. And here we have an attorney just doing his job, professional job, and you want to sue him for damages.
Well, let me finish what I was saying about the district court first, which was the court said that Mr. Miyares appropriately considered the intent of the legislature. Again, there was no need for interpretation whatsoever. Moreover, the defendant has misstated the intent of the General Assembly, claiming its purpose was to limit the applicability of enhanced good time credits when its declared purpose, according to the Virginia Supreme Court, was as an incentive for good behavior and rehabilitative activity while incarcerated. Now,
doesn't that underscore the basic point that this is really a matter of state law, and whatever label you put on it, whether it's an 8th Amendment or 14th Amendment, you know, as both of my colleagues have said, both Judge Niemeyer and Judge King, if we're going to string up on a state official for damages for doing nothing more than interpreting a law and doing his job, and a federal court barges in with that kind of a holding.
but Judge, we know that he was a political opponent of these provisions, and so he had a motive to do what he did as a lawyer.
Well,
We don't know whether, in fact, Mr. Clark actually asked for reconsideration, or whether this was a political position.
I mean, Justice Hugo Black was a champion of all sorts of New Deal legislation when he was in the United States Senate. And then when the cases came up before the court, he championed the New Deal legislation and found it constitutional. But nobody has ever said that somebody's experience in public life recuses them from sitting on a case. We'd be off to the races.
Fair enough.
I
But
didn't
the
get your
issue is
answer to how you address, why aren't we bound by Campbell?
I'm sorry?
Why?
No, I mean, you are bound by Campbell v. Florian, no doubt about it. But Campbell v. Florian didn't foreclose what we're arguing here today. What Campbell found was that the reaction of the Attorney General in South Carolina was appropriate and reasonable. Our argument is that it was not appropriate in this case, and it was not reasonable. In fact, it's interesting to see that the statement of facts by the defendant and the inclusion of the criminal records of my clients that are relevant to nothing in this case. I can only assume they put it there because of the argument somehow bad guys shouldn't receive the benefit of the law.
But Judge Niemeyer raised the point of where's the mens rea here? Where's the intentionality here? Deliberate indifference and shock the conscience and whatever, the Eighth Amendment, infliction of harm, they all require some significant element of intentionality. And this person is doing nothing more than interpreting a statute in a general way. He doesn't have it in for this person. He's interpreting a statute. He's interpreting a law. That's what attorney generals do. That's their job. That's our job, to interpret the law too. And I mean, I just don't.
One final point, if I may. I see where the court's going, but I want to make one final point.
Well, no, tell me what your final point is. You're an able advocate, and I want to hear your final point. It won't be your final point because you have some time for rebuttal.
I'd make a point that you're arguing that this Attorney General was stretching the law, and your argument could be turned around against you in this lawsuit. You're trying to stretch the law.
My final point was simply that even after the decision of the Virginia Supreme Court in Priest, which clearly laid out the law, Mr. Miyares persisted with respect to conspiracies to commit murder rather than attempted murder. And he did so in the Vasquez versus Dotson case. So he was told by the Supreme Court of Virginia exactly what needed to be done, and he rejected even the Supreme Court's opinion. That was not reasonable. Our position is, his position in the opinion and in his defense of that opinion was unreasonable, inappropriate to the serious risk here of spending an extra year in prison after the legislature had told you you are entitled to release. Thank you.
We thank you, and you've got some time for rebuttal. All right, Mr. Gallagher, let's hear from you, sir.
Good morning, and may it please the court. I'm Kevin Gallagher, Solicitor General of Virginia, representing Attorney General Miyares and Director Clark. With me today is Graham Bryant, Principal Deputy Solicitor General. In Campbell v. Florian, as you pointed out, Judge Niemeyer, this court held that legal error alone is not deliberate indifference. As this court explained, in our legal system, approximately 50% of litigants lose, and thus have pressed what a court has determined to be an incorrect legal opinion. Courts around the country, including this court, can be overturned. And even at the Supreme Court, up to 4 justices can sometimes share an incorrect legal opinion. Making legal error equivalent to deliberate indifference would transform routine legal disputes over the proper interpretation of state statutes into federal constitutional matters and accompanying damage claims.
Let me ask you this. I think the appellant is suggesting that we're entitled to review the legal opinions of attorneys general based on the substance of the opinion as opposed to the exercise of the attorney general's job to issue opinions and publish them for use by the executive branch. And I don't know if we addressed that in Campbell. The question I have is whether we should get in the business of second-guessing opinions substantively as opposed to looking at the circumstances about them. I mean, it seems to me there should be a strong presumption that when Attorney General issues an opinion within the course of his duties, that this doesn't give rise to a damage action.
It will probably not surprise you that I think that there should be a high bar here. I think the analysis that this court used in Campbell v. Florian is certainly relevant. There, this court looked at the reasonableness of the act of that official, looked at how he came about doing that opinion, whether he looked at the legal text, canons of construction, legislative purpose, things of that nature, and determined that that process is how a careful attorney would have handled that exact issue. Didn't look at necessarily the substance of the opinion. Although I will say, the lower court in that case, the state court, had found that that legal opinion that was on review for this court in Campbell v. Florian was unreasonable, found that it was patently erroneous, said that the lawyer
Which
there...
legal opinion are you talking about was wrong?
In the South Carolina decision that this court was
We're
reviewing.
talking about Campbell versus Florian.
In Campbell v. Florian.
You're not talking about this case.
I'm not talking about this
That's
case.
what
Actually, the exact opposite.
Right.
In this case, there was no finding of unreasonableness. There was no finding that there was a patently erroneous view of the statute. The Supreme Court of Virginia certainly disagreed with the Attorney General's opinion, but that happens every day in this court. That happens every day in the Supreme Court of Virginia.
And the two attorneys general, one took one position and one took the other. But that's the way things work.
That's exactly right. And I would love to go through those two opinions because I think it's very relevant here. Attorney General
I'm
Herring.
not asking you to go through them. I just know those are the facts of this case, though.
Those are the facts of this case. And both attorneys general, both Attorney General Herring and Attorney General Miyares, were dealing with a new statute the Supreme Court of Virginia had not reviewed.
And there's got to be a strong presumption that both of them were acting in good faith. They were calling it as they saw it.
That's exactly right.
I mean, that's where we have to start, I think.
I don't know how much authority you got for that, but that's my thinking about it.
I do think that this court in Campbell v. Florian looked at the good faith interpretation that the lawyer put forward, and so I would invite this court to do that here. Both Attorney General Herring and Attorney General Miyares were looking at this new statute. They just drew the line in different places. Both of them looked at the provisions of the statute and saw that there are certain carve-outs from the enhanced earning sentence credits definitely for completed acts of, for instance, a Class 1 felony. But that still left open the question about whether accessory offenses or inchoate offenses were included in that. Attorney General Herring decided that accessory offenses were included within the completed act. So the completed act itself, principal in the second degree, and accessory before the fact would all be not entitled to the enhanced sentence credits.
I mean, one of the most litigated areas of law deal with inchoate crimes. Attempted this, attempted that, but well, the whole area from which the dispute arose, which was an inchoate crime, is regularly the subject of dispute within this court. I mean, there are few areas more litigated in criminal law than the place of inchoate offenses, and that's what you have here.
That's exactly correct, Judge Wilkinson, and that's exactly why both Attorney General Herring and Attorney General Miyares decided to look at this new statute and see how inchoate offenses came into play.
What is there, do you understand, I probably ought to be asking your colleague, but is there any law that the Attorney General violated here, deliberately violated? I mean, any constitutional decision that it supports his position?
Not to my knowledge, Your Honor. I believe that he would point to, I don't want to put words in his mouth.
We also have this whole doctrine of immunity where public officials who are carrying out their functions are being sued in their personal damages for violating the 8th Amendment or the 14th Amendment, that you'd have to come forward with some law that said that they violated clearly established law in rendering that opinion?
That's exactly correct. We are here on a qualified immunity decision, and so there are two prongs of that, as you all know, and this court is welcome to rule on either, whether there was a violation or whether the right was clearly established. I've been making arguments this entire time about whether there was a violation. We take a very strong stance. There was not a violation of the 8th Amendment or the 14th Amendment here. But at the very least, on the clearly established prong, Florian v. Campbell would clearly establish the opposite proposition, which is to say that if someone were in fact doing what a careful attorney would do in this exact situation, they were not deliberately indifferent. And as far as substantive due process, I don't believe, and you can ask my friend on the other side, but I don't believe they have put forward any cases that would clearly establish
Supreme
anything.
Court may even regret its substantive due process doctrine, but they have very much narrowed it.
I don't disagree with you, Your Honor. I just know that at least in this particular case, there's no evidence of a violation of the 8th Amendment or violation of the 14th Amendment.
Is it your position that Campbell controls this case?
That is exactly correct, Your Honor. Campbell v. Florian is, if not on all fours, it's 3 of the 4. It is a different, obviously, factual situation in that it's a different attorney at issue.
Well, if anything, it's harsher because the district court did make a finding, and yet we said that still doesn't incur liability, made a finding of unreasonableness, but that we concluded that still didn't create liability. And of course, here the district court said just the opposite.
That's exactly right. And I just want to make one final point, although I'm happy to answer the court's questions. Deliberate indifference is an incredibly high mens rea. There were some questions from my friend on the other side about
Do you think
mens
this
rea.
case is under the 8th or the 14th?
We've made the argument in our brief, and I'm happy to make it here, that it should be a 14th Amendment claim. This court in Campbell v. Florian looked at those 8th Amendment and 14th Amendment claims and said that when it's the fact of detention as opposed to the conditions of detention, courts have more typically looked at that as a 14th Amendment claim, not an 8th Amendment claim. For the purposes of today, both of those would require at least deliberate indifference as the mens rea. So we really just don't think at the end of the day.
Well, a lawyer's entitled to frame it the way he wants to. The other side, I mean, that's what lawyers do too. I mean, we're arguing about that.
That's
I mean,
I hope we don't get
It's a
sued
reach,
for
any way you
picking the
look at
wrong
it.
amendment.
In this situation, it's a reach, but lawyers are entitled to do that.
That's correct.
At this point, I'm going to ask my colleagues here if they have any questions of you. Judge Niemeyer, do you have any? Judge King? We have no further questions, and we thank you for your argument.
Thank you, Your Honor.
All right, Mr. Fogel?
Just 2 brief points. Number one, I think it's been universally accepted that the standard of culpability under deliberate indifference is more than mere negligence, but less than an intention to do harm. And that's what we're asserting here. And very much like a legal malpractice case, in a
What is
sense.
your best case to
Pardon?
show that the Eighth Amendment was violated here?
I'm sorry, I don't have it at hand. It's all in the briefs, Judge. I'm sorry.
You don't know the case, your best case?
Sample v. Deeks from the
What's
Third
that
Circuit,
hold? What's that hold?
that the Eighth Amendment is the appropriate.
No, I'm not talking about that. That a attorney general who gives his opinion violates the Constitution when it turns out to be wrong.
I did not find such a case. I draw
Well,
my
Why
inference.
isn't that automatically entitled the attorney general to qualified immunity?
No, because the rule isn't as to which official may violate your rights, is that if an official violates your rights. And it shouldn't matter whether it's the Attorney General
official has to
or the
violate-
guard outside your cell.
Under qualified immunity, the official has to violate clearly established law that any reasonable person in his position would know that it violated it. Now, what law did he violate by rendering that opinion?
Well, I think
That he knew he was violating, or should have known he was violating as a reasonable person.
I think, Your Honor, the Campbell case lays out what would constitute an Eighth Amendment violation. It's very clear there. So we even have, although they didn't actually, the court didn't actually decide 8th or 14, they went through the whole analysis under the Eighth Amendment and found that he wasn't deliberately indifferent. So based on that, if we believe that he was
So what is your
deliberate,
case to go the other way? You have this attorney general, you accuse the attorney general of violating the Eighth Amendment because he issued an opinion that was reversed by the Supreme Court of Virginia. I want to know where is the case law that you rely on to say that was unconstitutional?
I don't have anything involving an attorney general making an argument, however bad, however frivolous, however much it might be
How about any
malpractice. I
government
have no
official?
such case.
How
Your
about
Honor.
any government official rendering an opinion?
Well, let
Do
me
you
just
have
turn.
an opinion? Do you have a case?
I don't have it at hand,
Well, now,
no.
how are you going to impute to this attorney general, how are you going to impute to him a violation of law that you don't even have a case to support?
The law is clearly established that any state official who inappropriately extends the sentence of an individual who's entitled to be released violates, some courts say the 14th Amendment, some say the 8th, some say both.
Don't you think that's pretty broad? Anybody who extends, sure, you lock him up and you hold him and he's supposed to be released, but that isn't what we have here. We have an attorney general interpreting a statute that it was later reversed by a court.
I get your point, Your Honor.
Yeah.
One
And
final
you
point.
substituted inappropriately for deliberately.
Well, some of the cases talk about inappropriateness as a standard, but the standard is deliberate indifference. One final point, which I think is important, because we have not really addressed what saves Mr. Clark from liability here. After all, he
Let me
had
ask
two.
you something. If Mr. Clark decided to go the other way, say the attorney general had gone one way and Clark went the other way, he's allowed to disobey the opinion of the attorney general in the
Yes.
administration?
Yes. It's an
And so
advisory
you're-
opinion.
You're, pardon me?
It's an advisory opinion. It is
Of
not
course it
binding
is.
on
Of course it
any
isn't.
state agency.
Of course it isn't, but the question is, you're now in charge of you're the warden, and you're trying to apply the law under a statute that's not been construed, and the attorney general gives an opinion, and you're saying the warden violates the law by following that?
He had two opposite opinions. It's almost as if he had no opinion at all. He could look at the statute was clear, the statute was unambiguous.
But all he did was request an opinion from the AG, and the head of state agencies request opinions from the Attorney General all the time. They
Yes.
can't, they can't wait and go through court and everything. They need to make a decision on a more accelerated schedule. And what they do is, when there's no opinion, they ask the AG, and the AG is simply the source of a great deal of guidance throughout state government. And if we hold a state official liable for requesting an AG opinion,
I'm not asking for the request, it's the implementation of that opinion, which was a choice that he personally
what's he
made.
supposed to do when he gets an opinion from the AG? He's supposed to follow it, isn't he?
But he didn't follow Attorney General's hearings. He had a choice at that juncture, like any client who got two opposing opinions from two different lawyers. And if you've got two different opinions from two different lawyers, it is the client that decides which opinion they want to follow.
So maybe that's true, but if he had a choice and he finds one legal view more persuasive than the other, we're right back into the difficulty of holding state officials, both elected and appointed, liable for simply making good faith efforts to try to resolve a difficult question of law. And this occurs every day in state government, that people make a request from the Attorney General as to what state law is required. And if he had a choice, fine. That simply points to a dispute. And
Well, that's pretty much what qualified immunity is all about, that these public officials need to do their work and go on. Call them as they see them.
Well, we know the law was clear and unambiguous, that any of us, and non-lawyers as well, could have read it and seen the truth. But I hear what the court is saying, and I don't wish to, what is the phrase, beat a dead horse, as it were.
well, I hope you'll let us say as well that we appreciate the vigor of your argument. It's a real pleasure to have you here, and we'll come down and shake hands with all of you. Is this okay with you that we go forward, or do you want to?
Yeah, I think we're all right.
You think
I'm
we're-
going to need room before we finish.
Pardon?
I'm going to need a break at least the next time.
Okay.
I can't get all the way through here.
But you're okay with
Yeah, yeah.
Okay. Is Bondi. Mr. Montesinos, Ms. Montesinos? Happy to hear from you.
Good morning, Your Honors. My name is Liana Montesinos, and I am counsel for the petitioner. May it please the court. In many cases, when a foreign government incarcerates a persecutor, it shows that it's able and willing to protect the victims. But in this case, we need to look further. In this case, Ms. Cruz escaped a country where gang members were conducting criminal activities within their prison cells with the complicity of the prison guards, and where one such prisoner surveilled her family, threatened her family with death, and sent his gang associates to her home. The Board of Immigration Appeals did not mention this evidence, did not grapple with the legal significant evidence here and the ones that we discussed in our brief. The Board of Immigration Appeals was...
Just as a matter of fact, I'm curious, I don't know the answer to this. The person that came purportedly to deliver the cell phone, do we know who that person was or the association of that person?
The record shows that when Ms. Cruz told the gang member that her phone was not working in order to avoid him...
I understand that background, but I'm talking about there. Somebody then, after that, came in the street, but she didn't engage him and he didn't come into the house, he didn't deliver anything. The question is, do we know, is there any evidence of who he was or what his association was?
I can provide the exact citation on rebuttal, but we believe it was a gang member because...
There's no evidence of that, is there?
Alexander then called Ms. Cruz and told her about the attempt to deliver, that he had one of his associates attempt to deliver.
Fair enough.
Today, I'd like to start with the 4 categories of legally significant evidence that the board ignored. And then I will discuss how the court should proceed in light of the Attorney General's recent decision reinstating matter of AB. The first category of evidence that the Board of Immigration Appeal ignored, and perhaps the most important facts of this case, are that while Alexander was incarcerated, he knew where Mrs. Cruz's son went to school, where her husband worked, how she looked like, where she lived, and was able to give orders so that his gang associates outside of prison would go visit her home. This is all happening in a country where the Department of State states that gang members committing crimes with in cahoots with the prison guards, it's a serious problem.
But one of the problems is here that Cruz didn't, the question is whether they were unwilling to protect Cruz, but Cruz never reported any incidents to them. Before someone is unwilling to protect someone, you at least have to give them a chance. And there were never any reported. There was never any report made about Alexander to the authorities in El Salvador. So, what do you expect from them?
Under Orellana, this court has held that a police report is not required if it shows... It may not be
required, but it certainly doesn't work in your favor. Because just as a matter of common sense, if you never give someone a chance to correct the problem, if you never reported it to them, that's a difficult thing. Now, there's a good chance that had you reported, these authorities might have done something about it, because unlike someone who's at large, Alexander was actually under their control. And they could have looked into the whole matter. He was incarcerated. They would have a greater degree of control over him. But they were never given a chance.
Your Honor, it is also a matter of common sense that Ms. Cruz didn't file a police report because an incarcerated gang member had this power over her and was able to know where her family was and where she lived and how she looked like, and was able to send a phone to her.
If he knew all this, there's still no evidence that Alexander ever harmed her Cruz or her husband or her son or anyone else. There's no evidence that this individual had actually harmed these relatives.
It is precisely because Ms. Cruz fled before that were to happen. She feared so much that he was going to harm her that she fled about 2 months after she changed her phone number.
Well,
And so,
we're here under a substantial evidence standard from the BIA and the IJ, and they both took they both took the view that there was a failure to prove that Salvadoran government was unable or unwilling to protect Cruz. And this, if we ruled for you, it would open up a broad number of cases from people who just claim generally that they were under some kind of suspicion or threat from somebody that they'd broken up with. And that would be a very broad extension of the asylum statute, to say the very least, particularly if we overruled both the IJ and the BIA for absence of substantial evidence.
well, Your Honor, this court has recently decided a similar case in McDougal, where the board decided on the likelihood of torture based on McDougal's mental health issues, but failed to consider other factors, such as race and his status as a deportee. The court held that the board had abused its discretion and remanded the case and left the definition of torture for another day. That is what we're asking this court to do today, to see the evidence and see that is legally significant, and that the board should have at least mentioned it. The board's analysis of this case ended with incarceration. They did not acknowledge that Alexander was able and had power to harm Ms. Cruz. And that takes me to the second category of evidence. According to the Department of State, open quotes, gang activities in prisons remained a serious problem, and prisoners reportedly conducted criminal activities from their cells, at times with the complicity of prison guards. Ending quotes, during Appendix 318. The country conditions put Mrs. Cruz's fear.
I thought there was a subsequent State Department report that indicated that conditions were in El Salvador, they were at one time very bad, but their conditions were improving in an effort to reduce crime.
Your Honor, the board took administrative notice of the 2022 Department of State report, but we believe that the board was wrong in including this report. It was legally faulty for two reasons. It was legally faulty, and at best shows that there are changed circumstances in this case. It was legally faulty because it didn't give Ms. Cruz the opportunity to challenge, for both truth and significance, what the report says. And regarding the changed circumstances, this is not dispositive of Mrs. Cruz's asylum claim. She could still meet the criteria for humanitarian asylum.
You know, there are a whole lot of crimes that are never solved in this country. And unfortunately and tragically, every day brings very serious crimes, much more serious, in fact, than what actually happened here. But the fact that a crime is not solved that would never indicate that American authorities were unwilling or unable to protect a particular individual if that individual never so much as gave them notice of what the offense was. I mean, you know, we're accusing or saying that the Salvadoran government was unwilling or unable in a situation where the government of the United States would be unwilling or able or unable to resolve an offense, even one that wasn't reported. I mean, the fact that something is not reported doesn't mean that the authorities are unwilling or unable to try to look into the matter if they've never been given that chance.
Your Honor, there's plenty of evidence in this record to show that there was impunity against gender violence in El Salvador. Also, her brother's murdered was not, the board didn't consider that they filed a police report and that the police had done nothing yet to investigate or to arrest the persecutors of her brother. Now, the standard in the Fourth Circuit is that a police report is not required if it is futile or dangerous, and there is overwhelming evidence that, including the brother's murder report, that it would have been futile. They didn't do anything for her brother, and that is significant because in asylum cases, other serious harm for similarly situated people is relevant. And going back to the country conditions, it really puts Mrs. Cruz's fears of the report being futile or dangerous in context and shows that the government would likely, in the way that they addressed the brother's murder, they would have addressed any other harm that she would have reported.
You focus solely on the country conditions? You're not interested in, you're not challenged in the social group?
Can you repeat that question again,
rulings?
please?
Correct?
Can you repeat the question again?
You're focused simply on the issue of El Salvador being unable or unwilling to protect people. You're not focused on any issue about particular social group rulings?
The parties have agreed that the recent case with the board presents challenges to this court's precedent in Amaya, and to the extent that the court wants to substantive rule on that issue, we would request for the agency to have an opportunity to reconcile this court's holding with the new precedent. For the third category of evidence, the Salvadorian government, as stated...
Just go back briefly to that. We have a precedent that says El Salvador women is a particular group?
Amaya v. Rosen
What's
says
that hold?
that it holds that particularity doesn't have to be restricted because a group can be subdivided.
Well, have we ever addressed whether the group entitled El Salvadorian women is inappropriate?
I don't have the answer to that, Your Honor. I can address that on rebuttal.
That's basically half the population, right?
Your Honor, both of the parties have agreed that if we're going to dive into this...
The board said that they said that was overbroad. The board ruled that was overbroad.
Yes, and that is in conflict with the...
And you don't challenge that?
We did challenge that in our brief. Then the government took the position that if the court wants to address that issue, it should remand. So both parties are in agreement that if that is the issue that is dispositive in this case, this court should remand for the agency to reconcile the law.
All right, thank you.
For the third category, as stated, the Salvadorian police failed to investigate Mrs. Cruz's brother's murder. This is significant because the treatment of similarly situated people is relevant in asylum cases. When Ms. Cruz was asked, has the police done anything to help your family out? She said, not so far. Joint Appendix 196. The authorities' lack of response in her brother's case, coupled with the country conditions in this case, shows that in El Salvador, it would have been futile for Ms. Cruz to file a police report. In El Salvador, about 1 out of 10 murders of women results in a conviction. For category number 4, the board also ignored legally significant evidence regarding impunity for gender-based violence.
Thank you very much, and you've got some rebuttal coming. Mr. Anderson.
Good morning, Your Honor. May it please the court, Eric Anderson representing the Attorney General in the case before the court today. In 2014, for about 3 months in El Salvador, Ms. Cruz de Sayans received telephone calls from somebody who said he was an incarcerated gang member. In these phone calls, he said she had to come to the prison to have sex with him and to deliver contraband, or else there would be consequences for her then husband and son. She didn't do those things. She told them she was not going to do those things. And neither she, nor the husband, nor the son suffered any consequences. These calls ended at the end of 3 months when she changed her phone number. And again, there were no harm inflicted on Ms. Cruz de Sayans or the husband or the son. She remained in El Salvador for between 1.5 and 2.5 months after the calls ended. No harm to her or the husband or the son. And in fact, as far as the record indicates, no one has ever sought any information or sought to locate her in the many years since then. Ms. Cruz de Sayans had a full and fair hearing at which to present her claim for relief to the board. The immigration judge and board considered all the evidence, and the record does not compel solely the conclusion that the government of El Salvador is unable or unwilling to control Alexander, and we'd ask the petition to be denied. I would start first on the issue of AB. There was, not to remind your honors of something you might be familiar with, but Attorney General said—
You're talking about those 28 J letters now?
One of the many in this case, Your Honor, yes.
Well, I said letters. There were
Yes.
28 J letters. There's several of them.
That's right.
And you got these cases that you described by initials. These
That's
are
right,
decisions.
because—
These are talking about decisions of the Attorney General,
That's right, and as we
which
know—
are binding on the IJ and the BIA.
I'm sorry, what was that last part again, Your Honor?
The decisions of the Attorney General binding on the BIA,
Yeah,
they're not binding on the Fourth Circuit.
That's correct, Your Honor. That's correct. As we know from the prior case, Attorney Generals can disagree about the resolution of issues of law, and that some of that is what's going on here. But the argument that seems most relevant is that Attorney General Sessions decided a case called AB1. AB1 repeated the long-established standard that if an asylum applicant fears a private actor, she has to show that the government is unable or unwilling to control that actor.
Unable or unwilling.
Unable or unwilling.
Are those statutory terms or Attorney General's terms?
Those are Attorney General's terms, Your Honor.
That's what I thought.
There's been a long history since
I was
then.
under the impression that that had been a standard for a good many years.
That aspect is absolutely the standard.
The
for
unable and unwilling, that's sort of become a standard, hasn't it?
Isn't that Fourth Circuit law?
That is, Your Honor. And the question is whether AB1 changed the result in no cases or changed the result in only a very small number of cases. And
Well, the question here is actually very narrow, and that is, does substantial evidence support the finding that the Salvadoran government was unable or unwilling to protect this petitioner?
that's correct.
And the BIA and the IJ, to whom we owe some deference under the substantial evidence standard, say that they made findings that petitioner had failed to carry her burden to prove that the Salvadoran government was unable or unwilling to protect her. And that's the narrow question before us, I think, and the question on which the BIA and the IJ decided. And so under the standard of review here, not only are we required to extend some deference to that, but I think it was the case of Consejo Fonseca that to reverse the BIA in this situation, the evidence would have to compel a finding to the contrary. The evidence would have to compel a fact finder to rule to the contrary. And that evidence is not present here.
That's absolutely correct, Your Honor. I disagree. I agree. I'm sorry. I agree with all of that, Your Honor. Yes.
Oh, do you need to hear anything further on that? Pardon? Bob, do you need to hear anything further from this?
Yeah, I wanted to ask him about Loper
Sure.
Bright. Yeah.
Yes, Your Honor.
I wanted to ask you about Loper Bright
Okay.
and these other letters that we've gotten. There are multiple letters, 28J letters.
That's right. I can start with Loper Bright. What had happened here was that obviously Loper Bright removed Chevron deference from being an issue. And on the basis of Loper Bright, Ms. Cruz de Sayans argued in this court that you should not apply an unable or unwilling requirement, that a private actor can show she is eligible for asylum. I'm sorry, an applicant can show she is eligible for asylum for harm by a private actor without showing unable or unwilling. And our response to that is, on the same day I filed my answering brief, this court rejected that argument in Molina Diaz. So it's not.
Did you argue Molina Diaz?
Did I argue Molina Diaz?
Did you argue that? Were you the lawyer in that case?
I was not the lawyer.
That's Judge Quattlebaum's decision here.
I don't remember the author, Your Honor.
Yeah, well, it is. February this year.
It was. It came down the same day I filed my answering brief, so it was the subject of the very first of those many 20HA letters, was that Molina Diaz resolves this. Molina Diaz also weighs on the substantial evidence review because it says the agency can look to be more persuaded by the facts in a particular case, such as Alexander being detained, not harming her from detention, her family was willing to make a police report and did not suffer harm as a result of that. Molina Diaz says the agency can rely on that kind of evidence.
Wouldn't Loper Bright have more force when you're talking about an agency's interpretation of a statute than it would as to a question of just reviewing agency fact-finding?
Yes, Your Honor. I may have lost the Loper Bright thread there, but yes, Your Honor.
Yeah, but the Chevron deference is out the window where we're talking about deference to a statute, because that is the court's, because that is the court's job, and that's what Loper Bright says. But then when we're talking about fact-finding, like here, that is the agency's job. And so the same degree of the deference that we would no longer show under Chevron, because courts are final authorities on statutory interpretation, is not applicable where we're talking about simple agency adjudication fact-finding, because that is any fact-finder's primary obligation in duty. So it doesn't mean that agency fact-finding is suddenly thrown overboard.
Perfectly put, Your Honor, yes. Judge King wanted to know more about the additional 28J letters, in particular the one about cognizability of the Salvadoran women social group.
Yeah, both of those
Okay,
points,
yeah.
but
So moving on to that, to be clear, the government absolutely thinks this petition should be denied. But we have said, if you wanted further consideration of the unable or unwilling, you could also send back the issue of the cognizability of the social group. We said that.
Just before you get on that and get the unable and unwilling, I thought we had determined as a statutory matter and not as a deference matter under Chevron, that is a correct interpretation of the statute. Don't we hold, the Fourth Circuit, without deference to the agency, that the standard is to show that the government, in a private circumstance, that the government was unwilling or unable?
Yes, Your Honor.
And so we're not involved in Chevron is really irrelevant on that issue for us.
That's right. Molina Diaz said that exactly, so yes, Your Honor.
Yeah. All right, I didn't want to, and you wanted to answer Judge.
This is on the other issue in the case, whether there is a particular social group. At the time we filed our brief, there was no published board decision, which admittedly, a published board decision doesn't matter for yourselves for Chevron reasons anymore, but it definitely matters because the regulation says precedential board decisions bind immigration judges and asylum officers and people in my office, certainly. So it matters if we have a precedential board decision on a group based on gender. At the time in February, we didn't have it, but now we do. We have matter of KESG, which was the subject of what I believe is the second 28J letter.
is that the one this week?
A few weeks ago, Your Honor.
2 weeks ago? Yeah.
Three or 4 weeks
Two
ago.
days ago?
Not 2 days ago.
A few days
Oh,
ago?
yes. I think 3 or 4 weeks, but
Okay.
there, the board did decide that the group of Salvadoran women was not cognizable. It lacked the particularity required to be a cognizable social group protected by the INA. And my letter in the case said that this did not change our litigating position in this particular case, which is deny the petition on unable or unwilling. But if you disagree, you can still send it cognizability back to the board. And the reasons why I think are twofold: to see whether the board would apply its holding about particularity in this court, given its own rules about particularity, which is to say, in this court, particularity is a question of what does the dictionary tell you a word means, whereas the board has always understood it to be a matter of what is the evidence about what these terms mean in a particular country. To see whether the board would apply it given this court's background, or whether the board could also rely on other issues of social distinction, or even the matter of an issue raised for the first time in KESG, which I would just briefly summarize as, if you go through the United States Code, you're going to see many statutes granting protections on the basis of race, gender, other categories. In here, we have in the asylum statute, we have a protection accorded to some of those groups, but sex and gender is explicitly not listed. And it would be a great change for an agency to suddenly decide that in 1980 in the Refugee Act, Congress had meant to extend relief and protection to individuals based solely on their sex or gender. And that's another issue the board could resolve if the case came before them. But for all the issues about unable or unwilling, we don't think that's necessary in this case.
Do you have anything further?
No, Your Honor, I thank you for listening, and we'd ask for the petition to be denied.
Judge King, do you have any? Judge Niemeyer? We're fine, thank you.
Thank you, Your Honor.
Ms. Montesinos, you have some rebuttal time.
Thank you, Your Honor. The key inquiry here is whether the BIA ignored legally significant evidence, not whether the evidence compels the conclusion. The issue here is that the BIA did not do any fact-finding regarding the complicity of the prison guards with the gangs while incarcerated. This is what makes this case different than what happens in the United States. There is no Department of State report about the United States prison guards having complicity with gang members. The board abused its discretion because it did not grapple with the legally significant evidence or even mention it. As stated in McDougall and also in Funes Ortiz, this court held that an agency must grapple with legally significant evidence and can abuse its discretion if it doesn't even mention it. We have 4 categories of evidence here, and although the 2022 report is not in the record, it does not show that the problems that were present in 2023 have changed. In Amaya, the board found that Salvadorian women was not particular because it can be subdivided. This is in conflict with Amaya v. Rosen, which states exactly the opposite. The intention of the unable or unwilling element is to protect asylum seekers when a government is unable or unwilling to protect them. In this case, in Orellana, the Fourth Circuit states that if it's futile or dangerous for the asylum seeker to report, they don't have to do that. And
No, but you know, in the big picture, the bigger question is asylum is basically based on government persecution and not private conduct. Private conduct is only implicated if the private conduct can be somehow imputed to the government. And the standard we have been using is if the government is unwilling or unable to address the private conduct. And here we're talking about private conduct. You're talking about a threat from a gang member, and the question is, how do you impute that to government conduct? And the standard we've applied, and I think we've done so despite any deference under Chevron, is unwilling or unable.
in this case, Ms. Cruz showed that the prisoners were in cahoots with the prison guards who were part of the government. And so it clearly shows that the government was unable or unwilling to protect these private actors. There is evidence due to ineffective governmental institutions.
Well, he was still in detention, wasn't he? They didn't let him out.
But they were not able to control him, and he was still able to conduct criminal activity.
Well, we don't know that. I mean, he's threatened, but he didn't, we don't know of any harm he caused her husband or her son, do we?
It is not in the record whether he was able to effectuate the threats that he made, but he was able to send his gang associates to her home. He had seen
We don't know
pictures.
the gang associate either. We just know that there is thin evidence that he had somebody go. It could have been a friend. It could have been it could have been anybody. We don't know. All we know is the source of that. There's a thin evidence that Alexander was the source of that man's presence, but we don't even know whether that was the man. I mean, that could be a misinterpretation because he was there and he didn't deliver anything. He didn't talk to her, engage with her. It's very thin. But quite apart from that, that's why I asked you that question in the beginning, is whether he was a gang member. We knew it, and we really don't know.
The fact that he had people running errands and conducting criminal activities for him on the outside of
You
prison,
could do that in the United States. I can call up from prison, I could call up my brother and say, will you go deliver a birthday card to my wife? And that could be done, right? I don't see what's so unusual about that.
the problem is that he sent someone to deliver a phone for her because he wanted to keep on threatening her and manipulating her, eventually so that he could get her to have conjugal visits with him and to bring him drugs. The intention of his constant communication with her was not a simple phone delivery. It was to conduct criminal activity.
All right,
And that's
thank you. Thank you very much. Did you want to take a break? Okay. We'll come down and greet counsel and take a brief recess.
This honorable court will take a brief recess. judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. All right, we're here to hear our final case, Singh versus Bondi, and Ms. Moreira, or Mr. Moreira.
Good morning. Good morning to the honorable court. My name is Guido Moreira, and I'm here arguing on behalf of my client Gurvinder Singh, in Singh versus Bondi. It's a case in which my client was found to have submitted a frivolous asylum application, which forever bars him from any form of relief under the Immigration and Nationality Act. The government has raised some arguments regarding the court's jurisdiction in this case that I'd like to briefly address, based on the Supreme Court's decision in Patel v. Garland, arguing that this frivolous asylum finding relates in this case to a discretionary determination regarding adjustment of status, and that the court would not have jurisdiction to address the issues raised in the petitioner's brief. But I do think there is an important and interesting legal argument in this case, and legal issue, which is whether the agency, the BIA or the immigration judge, has a discretionary authority to withhold entering a frivolous asylum bar, even after finding that the requirements of the board under matter of YL have been satisfied. And one reason that this is a very interesting legal issue is because, in fact, the BIA has declined to address this issue in many circumstances, even though it does potentially affect a large number of cases that come before it, and that would eventually end up in federal court such as this one. And now in our brief...
Now, what's the issue you say they declined to address?
Whether the agency, being both the BIA and the immigration judge, have the discretionary authority not to enter a frivolous finding even when the factual requirements of a frivolous finding have been met. And
Is that based on statute?
It is based on the statute. The statute. So the persuasive authority that we discuss in our not persuasive authority, but the persuasive analysis that we discuss in our opening brief is regarding the Second Circuit's treatment of this issue in Meijuan Zhang v. Mukasey and Meijuan Zhang v. Holder. And in those cases, the Second Circuit looked at the statute and at the regulation, which is that the statute is 8 U.S.C. 1158 at D6, and the regulation at 8 CFR 208.2. And the Second Circuit determined that it's ambiguous as to whether the word determination in the statute is referring to simply applying the requirements of matter of YL, or whether this word determination includes a discretionary element. And the Second Circuit noted that the BIA had not issued a published decision about this. They did invite the BIA to address this issue, and the BIA only issued an unpublished decision about it, which the Second Circuit found not to be persuasive. And so the Second Circuit, in its 2012 decision in Meijuan Zhang v. Holder, they did determine that there is discretionary authority for the agency to withhold a frivolous asylum finding, even when the requirements of a frivolous asylum finding have been met, and this would be based on discretionary equity. In the present case, the immigration judge and the BIA both, again, declined to actually address and answer the question of whether there is discretionary authority to do so. However, the immigration judge indicated that it was not necessary to decide this legal issue because even if it was that the discretionary equities in this case would not be sufficient, to make that discretionary determination. And our argument, as we set forth in the brief, the BIA ended up adopting and affirming the decision of the immigration judge without really adding any of its own analysis or findings. And our argument that we raised in the brief is that being that the immigration judge is now the final agency determination after being adopted by the BIA, that it's not actually sufficient to uphold that conclusion that the discretionary authority that it need not actually reach the issue of whether it has the discretionary authority to withhold the frivolous asylum finding because of certain negative equities. And in this case, the immigration judge pointed to the fact that in this case, Mr. Singh did admit that he lied about his asylum claim, that he said things that happened that did not happen. And they said that those negative factors.
Everything he said is pretty much.
Yes, his asylum claim, yeah, everything he said was he
made it up out of whole cloth.
Yeah, well, what he says is that
he said his lawyer made it up.
His lawyer made it up. That's correct.
Well, other places he said he made it up. There's a tension in his own testimony.
Well, that wasn't in his testimony. That was based on, I believe that was based on what USCIS said that he said during their investigation.
I remember reading, I'm not quite sure where the testimony was, but it was actually quoted testimony of his where he said he agreed he had made it up. And,
I understand. I believe that in this case it may have been a misunderstanding, but that when he spoke about it at length and in detail, he said that what happened was he gave his real story to the lawyers. The lawyers worked on it to write up his written statement, and then when he saw what they had written, he saw that they made up a different story, and they told him that this is what you were supposed to do. This is what you have to do.
Going back to what he had to do to win his case.
Yeah, that is what he has to do with his case. So there's an issue where he was relying on legal counsel, and they told him to do something that was certainly.
I'd have to go back and look at this, but there were several references earlier where he took responsibility for making it up and creating it. And I sort of think that it was late in the game he started pushing on to the attorneys, and it looked like an additional effort to deflect his responsibility.
Yeah.
But that would require some spelling out in the record, but that's what I remember reading.
Understood. Well, I believe I believe it may have been that he was just admitting at first that the story was made up, and later he went into more detail about how the story was actually created.
What he wants is to get asylum now, in spite of the fact that he made up this false story in his first effort to get asylum.
Well, the main issue that he was going for in front of the court now.
Pardon?
I'm sorry?
I say not a lot of equity on his side.
That's correct. The main equities on his side, as far as discretionary equities, is his ties to U.S. citizen family members who he takes care of and who would greatly suffer if he is removed from the United States. And the most important thing that the immigration judge did not do in this case was actually discuss any of these positive equities in determining that even if he does have discretionary authority to withhold the frivolous asylum finding, that it would not be warranted. And the reason that that's an error of law is because the board has made clear in its published decisions that, that making discretionary determinations requires factual findings and weighing positive factors as well as negative factors. In the current case, the government argued that there actually are no discretionary factors that are required to be looked at in this context, because that would only apply in context where someone is applying for relief. But I do have a citation I'd like to bring up, which is matter of MMA. That's 28 INN 494, and that's a BIA case where they discussed discretionary matters having to do with the frivolous asylum finding, but they did ultimately decline to decide whether there is such a discretionary authority to withhold the frivolous asylum conclusion after the requirements have been met under matter of YL. And in that case, they did leave it open that an immigration judge could make a discretionary determination in this way, and that the BIA itself would then have a de novo review over it. And they emphasized that in order for them to have that de novo review and exercise it properly, the immigration judge has to weigh the positive and negative factors to put it into the record, since the immigration judge is the finder of fact, and the BIA would be looking at their findings.
Is this a recent case?
This was I believe this was 2022, so it's somewhat recent.
I'm not sure how these so-called equitable factors can overcome the string of just outright lies. He had to know what his lawyer was saying, but there are so many issues here that went directly to the question of materiality and to the heart of whether there was a well-founded fear of persecution. And that's just a basic hurdle that somebody has to cross as to whether there's a well-founded fear of persecution. And there's just a string of lies here, lie after lie after lie after lie. And I don't understand how the discretionary factors can overcome the fabrications that about his brother disappeared, and he had all these threats and threats of harm and threats from Indian police and all the rest, and they're just fabrications, they're just false. And if we were to reverse the IJ and BIA here, wouldn't we be putting a premium on lying?
I certainly don't think that we would be rewarding lying in this case by requiring the BIA to actually follow its own. In this case, yeah. In this case, certainly the facts of what my client did.
Excuse me. Here you have a situation where the whole asylum process rests upon credibility. And when we often look at these cases, we say, well, did the IJ make a finding about whether the witness was credible and the rest? And the entire asylum process depends, it seems to me, to a considerable extent on truthfulness and honesty. And this isn't just one lie, it's lie after lie after lie, and it goes directly to whether there's a well-founded fear of persecution. And I think if we were to reverse the district court on here, we would be inviting and encouraging the manipulation of facts and fabrications and untruths. And this the asylum process, as you know, is one where people have an incentive sometimes not to tell the truth so that they can get a favorable result. And there are many people that do tell the truth. No question about that. There are many people that are credible. But there are also people who are not credible at all, and they, because of the incentive that exists to succeed on an asylum claim, they make up stuff. They make up claims. And a decision along the lines that you've mentioned to us, I keep coming back. I think we would be putting a premium and putting a green light, flashing a green light to misrepresentation, fabrication, and courts can't work on that basis, whether it's an asylum claim or whether it's an ordinary civil case. We have to, our whole system depends upon honesty. And that's what was missing here. And that's what we shouldn't encourage. That's my problem with what you're saying, is that whether it's an immigration case or a criminal case or a civil case or a witness or a applicant, a petitioner, the whole system depends on truth. And if it lacks truth, it collapses like a house of cards. And I just want to be honest with you, that's my problem. It's not you've given a good argument, and I respect that, but I have this basic difficulty. You see what I'm telling?
I certainly understand and associate and I even have the same concerns myself, but in this case, we're not asking the court to weigh any of the equities in themselves, but it's about requiring that the agency actually, that it enforce its own that it decide for itself whether this authority exists, which it's kind of avoided doing and declined to do, despite being invited to by federal courts for maybe as much as 2 decades now, that they've consistently declined to decide the specific issue, and then because of the board's own precedent saying that the discretionary factors have to be addressed in an explicit manner by the immigration judge, for the board then to have its own decision that the BIA actually erred as a matter of law in this case by rubber stamping the immigration judge's decision, where the immigration judge did not actually comply with the board's precedent and
Thank
binding
you, counsel,
authorities.
and
Thank you.
I also note that you have some rebuttal time that you've reserved.
Thank you very much.
Ms. Snyder?
Good morning, Your Honors. May it please the Court. My name is Alana Snyder. I'm appearing today on behalf of the United States Attorney General. We're asking Your Honors to dismiss in part and deny in part this petition for review for 3 reasons. First, the Court does not have jurisdiction to consider the agency's determination that petitioner is ineligible for discretionary relief pursuant to the discretionary review bar at 8 U.S. Code Section 1251A2BI and Patel v. Garland. Second, even if the court determines that it does have jurisdiction, the agency's frivolous asylum finding is fully supported.
In which case we deny everything,
In which case you deny everything.
or affirm.
I deny the petition for review, the dismissal part of the petition.
Deny the petition for review.
Yes, yes.
Well,
Your
why
Honor.
wouldn't you just want to deny rather than get into this thorny issue of, we've been wrestling a long time with what's discretionary, what's fact-finding, what's discretionary,
Sure.
what's a question of law or of constitutional law. We could wax very philosophical about the nature of fact and the nature of law, and yet the case has a basic problem here, and that is a problem with honesty and truthfulness, and you just go to the heart of it and deny the petition. You wouldn't want to get all tangled up in this other business, would you?
I think that's a fair question, but I think when there's a jurisdictional question that we think is squarely presented before Your Honors, we have the obligation to bring it, and we think that the court, wants to at least get involved with answering that question. We think Patel is a square application here. We think there's a lot of similarity with Patel, right? We had an adverse credibility determination in Patel, a disqualification for adjustment of status on the basis of inadmissibility, which of course was in the statute, is in 1258 U.S. Code section 1255 subsection A, and here we have a disqualification for adjustment of status based upon 8 U.S. Code section 1155 D6. So I do think there's a lot of parity between and similarity between Patel and the instant case. So I do think the government brings this up before Your Honors, not just because we have a strong case on the frivolous asylum claim, as Your Honors very aptly pointed out previously when my friend was before Your Honors, but also because we think we have an obligation to bring it before the court.
Well, I'm not quarreling with your
Sure.
obligation, and I understand it, because you have a client, and and here you are. But then again, you would not necessarily quarrel with my assessment that there may be a very straightforward means of addressing this case that would spare us
The pain.
the nettlesomeness of a legal tangle. It's not a desire to avoid a jurisdictional question. It's just a desire sometimes to dispense what is obviously a just result in a straightforward and an expeditious manner.
Absolutely, and I think to both Judges King and Miyares' questions, I think it's absolutely very clear that the petitioner, and of course Judge Wilkinson, what you were talking about before, I think it's very clear that the frivolous asylum finding in this case is fully supported. The petitioner did in fact fabricate two major claims and also omitted a major part of his history, the fact that he had served in the Indian military for 16 years, which would have prevented an immigration judge from at least examining whether he had some sort of bar to asylum. But to your specific question about whether the petitioner had flip-flopped on whether it was him who made up the story, I would direct Your Honors to pages 691 and 692 at the administrative record.
I've got it right before me. and
Okay. Okay.
He said he had a little help, but he said, I made it up from facts that I knew back in Amiristar. He says, when you say you did the story yourself, what does that mean? Me and the other guy. And then he says, how did you come up with the arrest? These happened so that that gave you ideas. He says, I'm from Amiristar. There's a lot of cases like this over there. That's in mind. A lot of people killed. So I told him, I'm from here, from the village close to Amiristar. We see a lot of cases over here. I mean, he goes on and explains how he got it. He said, this one means specific instances of harm. Yes, I made my story myself, and this guy helped me a little bit, and that's what he gave me to a guy, a lawyer named.
Yeah, and the immigration judge did give the petitioner an opportunity, multiple opportunities at administrative record 286 and 311, the opportunity to explain this sort of testimony and sort of try to reconcile the fact that later on in his testimony he had stated, no, actually it was just the attorney. So the immigration judge did what was exactly required here under that 4-part test that my friend had referenced in matter of YL.
Address, your colleague talked about an implicit right to waive in a Second Circuit opinion?
Yes, the Zhang case.
What's your position on that?
So our position is that the court doesn't need to reach the Zhang case. Really, I think the question of the Zhang case comes up as to whether or not it's a matter of discretion, whether or not the immigration judge can launch a frivolous asylum finding in the first instance. And so part of the reason why this would even come up is whether if the court goes down that jurisdictional route that Judge Wilkinson and I were just discussing. So if the court goes down that jurisdictional route, then of course the court would only have jurisdiction over over legal determinations.
And constitutional.
And constitutional questions, of course. And so I think my friend is bringing that up to say, well, if the question of whether the immigration judge has discretion to launch that inquiry in the first place, that of course would be a legal question. We don't dispute that. That obviously would be a legal determination. Our position on that is that question is irrelevant to the disposition of this petition for review, and that's because the immigration judge basically said, I'm not going to resolve that. The board has said, we're agreeing with that. That is irrelevant here because even if I did have the discretion, I'm going to assume I have the discretion, basically I would not exercise my discretion to withhold that frivolous asylum finding. Essentially, I would go on to find you frivolous. And contrary to what my friend said, the immigration judge did discharge a discretionary analysis. The immigration judge on page 210 of the administrative record went through factors. It's just factors that I'm sure my friend didn't want to examine, which essentially was the reason why petitioner had the length of time that he had in the United States is because he lied on his asylum application and then was able to bring over his wife, who then became a United States citizen and, by the way, reapplied for him to adjust his status. So the reason why he was able to readjust his status is through his wife, who got her status as adjusted her status to a green card holder through his original fraudulent application. So the only reason why he has all of these equities, essentially, says the immigration judge, is through that original fraud in inception. And so again, the immigration judge did look at these discretionary factors. It's just that it didn't come out the way that the petitioner would have liked. So again, Your Honors, there's really, even if the court wants to say it's a discretionary analysis, which I don't think Your Honors have to, it would still come out not in favor of what the petitioner is asking for here.
Anything further?
With respect, unless Your Honors have any further questions.
Well, let me, if Judge Niemeyer, you have any further questions? You have further questions? You're fine.
Thank you.
Mr. Marrero, you have some rebuttal time.
Thank you, Your Honors. I would just like to add on a little bit of discussion regarding the Second Circuit's analysis in Zhang. They did actually specifically discuss that there's two separate places where the discretionary decision of an immigration judge could possibly come into effect when it comes to a frivolous asylum finding.
What discretion are you focusing on in this case?
So in this case, I'm discussing, since the immigration judge.
Let's assume you have discretion. What's discretion to do what?
So the discretion in this case would be to say that even though Mr. Singh has submitted a frivolous asylum application that meets the requirements for a frivolous asylum application finding under matter of YL, that there still would be a discretionary authority to withhold that ultimate frivolous asylum bar based on positive equities such as.
But that's not in the statute.
That's not in the statute. But the Second Circuit said that it's ambiguous, and the BIA has repeatedly declined.
That'd be the same as disregarding his lies and awarding him asylum.
Well, in this case, it wouldn't be awarding him asylum. In this case, he was applying for a different form of relief many years later after his frivolous asylum finding. And that's the procedural.
He was applying for citizenship, wasn't he?
Well, he had been applying for citizenship, and that's when it came to light that he had lied in his asylum. He was then placed in removal proceedings.
That's what I remember reading. I just, your colleague quoted that from his testimony there. And he said, I made it up with a little bit of help here. And then he explained how he made it up and why he made it up. And then later in the proceedings, he seems to want to deflect it all to his attorneys, which I found disingenuous in and of itself.
Yes,
That's a terrible accusation to make against your lawyer, that his lawyer made up this false story to get him to file it all.
Well, certainly it is a very serious accusation against the lawyer.
If it's true, or if it were true, that the lawyer's not fit to be practicing law.
Not only would the lawyer not be fit to be practicing law, but it's possible that the lawyer could be something along the lines of a criminal, could be doing this in many other cases.
Well, certainly.
And could be coercing people in a way that ends up causing them very, very harsh consequences under the immigration law. So the idea that there may have been some coercion from an attorney involved is certainly at least some consideration that could be relevant for a discretionary decision.
He starts pleading that it was my attorney's fault. I didn't know this stuff. That really is a real overstatement.
Well, I think it's clear that the attorney was involved closely in at least working with him, and I don't think there's anything in the record that really directly contradicts his claim that they're the ones who told him that he shouldn't tell his real story, that his real story wouldn't do, and that he needed to tell I guess a stronger story that they worked on with him, which of course that is very terrible on behalf of those attorneys who helped him. If it and for that, but that is something that would go towards this kind of decision if there is the authority to make a discretionary analysis after determining that YL applies.
So the Second Circuit is the only circuit that's applied that implied waiver, and the agency refuses to adopt it. Is that what you're telling us?
As far as I can tell, I don't think any court has specifically said that there is no discretion. The Second Circuit is the only one that said there is, and that was a big part of that analysis was the fact that the BIA did not issue a published decision and only issued an unpersuasive, unpublished decision indicating that they couldn't exercise this form of discretion. Whereas in their published decision in MMA, they said that an immigration judge should weigh all positive and negative factors on the record so that they could issue a de novo, a discretionary analysis in their own decisions.
All right, we thank you very much, sir.
And thank you to the court.
We will adjourn court, and I want to thank our courtroom deputy for all her good assistance. And we will adjourn court and come down and shake hands or fist bump hands or whatever it's called.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.